10, my lord. Dismissing the writ petition on the finding that, my lord, principle of res judicata is applicable in respect of proceeding involving tribal land under OSA TIP regulations, my lord. Orissa Scheduled Tribe Transfer of Immovable Property Act, Regulation 1956, my lord. On the basis of application under Section 3A of Regulation to 1956, my lord, a proceeding was initiated by the respondent number 2, my lord.
Yes.
And the case was registered at RMC 15 of 2004, my lord. And the respondent number 2 has categorically discussed that res judicata is not applicable in the instant case at running page 31, my lord. Running page 31. May I place, my lord, running page 31.
You just straight come to the reasoning of the learned single judges, page 48. Straight come to that paragraph of
My
the
lord.
second paragraph of the order dated 8/8/2017.
My lord. Under the circumstances, this court finds there is no
the second paragraph. The impugned order has been
the
essayed.
impugned order has been assailed on the premises of illegal application of principle of res judicata to the present case. Even though the certified copy of the proceeding involving first round of litigation is not available on record, but on a close reading of the discussion made by the competent authority involving the 3A proceeding under the Regulation 2 of 1956, as available as page 28 of the brief, this court finds the previous round of litigation by RMC 12 of 67, a proceeding initiated under Section 3(1) of the Regulation to 1956, admittedly involved the brother of the present petitioner. And the opposite party herein. Further, the dispute also involved the property involved here. Under the circumstances, this court finds there is no illegal application of the principle of res judicata, and for the dispute being adjudicated by RMC number 12 of 67 being raised by co-sharer, and for not being further challenged by the co-sharers of the property, the order passed therein remains conclusive. Hence, the dispute involving the same property.
So there is a two questions from this court. Whether the petitioner was a party to that earlier proceeding?
No, my lord. He was not a party to the earlier proceeding.
Whether you have authorized your brother to represent the interest of the entire property?
No, my lord. That is my question.
Yes, Mr. Mohanty.
Yes, my lord. So, Lordship may kindly
No,
say.
we're admitting this appeal.
Yes, your
It was a
Lordship is saying
private
that this
party.
particular petitioner was not a party in that proceeding. But as it appears, your Lordship admittedly involved the brother of the present petitioner and the opposite party herein. Further, the dispute also involved the property. So the same set of allegations.
Sorry, this is not the principle of res judicata.
No, I am not telling about dispute, but the dispute has already been
Maybe that is
adjudicated
I asked him a categorical
at the instance
question
of his
whether
brother.
he authorized his brother to
then-
represent the entire
then your Lordship,
property.
there will be no end to the litigation. Again, another brother will come.
There should not be any end of the litigation because all the parties are not brought on record. It is a land where all the co-sharers have their own interest. And you are not bringing all the co-sharer on the record. You are taking a decision. Other co-sharer have their say. Unless, of course, they are authorized or them to represent or they are appearing before by
In that case,
power of attorney.
He must compare with the petition of that first RMC case to know whether this petitioner was opposite party in that case. I believe that he must have included. He is the petitioner.
If he is implemented, all right, the principle will apply.
That is what my.
But he made a statement that he was not a party.
That is not there. He is saying that, but no annexure is there. In the earlier.
That is why we are issuing the notice. Let us examine this matter.
My lord, my response, he must compare with an annexure the earlier order which was passed at the instance of.
Do you have the copy of the application of the first case?
This petitioner was added as a
RFC number
party.
12 of 1967.
That has been discussed.
From the impugned order, it is obvious that his brother was a party and he was not a party. So
It appears that from the
yes.
order itself, my lord, under annexure word.
No, principle of res judicata is a tool just to scuttle the unnecessary litigation on the same issue.
Exactly.
The parties must be there in a When someone was not a party in the previous proceeding, against him, you cannot apply the principle of res judicata.
Yes, your lordship is correct, but your lordship may imagine these are two brothers of same uterine brother, not that. So
We also
one
direct
after
you
the
to,
other, they are coming
we also
to court.
direct you to produce
Yes,
the
your
reports of
lordship have
RMC number 12 of 2006,
Yes, your lordship have
1967, 1967.
because the beneficiary has to be noticed. He is included as
That is
opposite
why you are
party.
Mr. Nanda or Mr. Sahu,
Sahu, my lord.
Mr. Jain Sahu, Lord Counsel for the appellant. By means of this intercourt appeal, the order dated 8th August 2017, delivered in WPC number 2775/2020 has been challenged. A learned single judge of this court has dismissed the writ petition, holding that the petitioner cannot raise the ground which he has taken, in as much as in RMC number 12 of 1967, his brother was pleaded about the land, which is admittedly a joint property. Stop. Call for the records of WPC number 2775 of 2010. Stop. Since Mr. D.K. Mohanty, Parent Council, appears and waives notice for respondents number 1 and 2, no formal notice is called for. But the appellant shall take steps for service of notice on the opposite party number 3 within 3 days from today. Notice is made returnable on 11th of August 2023. We would direct the opposite party number 1 and 2 to produce the records of RMC number 12/67. Stop. The appellant is also directed to remove the defect within 3 days. Remove the defects as indicated by the registry within 3 days from today. No further accommodation will be made for that purpose. There are 2 defects you have to remove.
Lordship has directed them to produce that case record.
We have directed respondents number 1 and 2 to
Yes,
produce the
we
records
are
of that proceeding. Let us see whether there is a party. If he is a party, he cannot do, but it appears from reading of the order
On the bare
that he was
perusal
not a
of the-
party. Let us see, okay.
Item 2.
And what about the other matters? Mr.
Other
Su-
also same, my lord, only RMC number different.
All right,
And
just check up in the order.
Yes,
This
sir.
number will be different, but other orders
Same.
are same.
same.
Same RMC.
And the opposite
well.
party, this is
Now,
a,
Different
in
RMC.
those cases, the RMC case records which we are required to call for, that number is different. Your lordship may kindly,
we are reflecting in the order. You are
that
reflecting.
number will be changed.
No, that we have already
Yes,
directed. Yes, it will be changed. Just a certificate copy of the impugned order, you will find the number. All right. Call the next.
Item 2.
May I please your lordship, madam. Your my lord, I am challenging the order dated 23/3/2023 passed by the Honorable Single Judge in WPC number 3803 of 23, my lord. I have filed a writ application before the Honorable Single Judge regarding the order passed by the Permanent Continuous Loco Adalat, my lord.
Yes.
On the ground that in the Permanent Continuous Loco Adalat, the present respondent number 5 filed an application for compromise. Though the compromise petition was drawn up according to the share of the parties, but the map was not drawn according to the compromise petition, my lord. So when the petitioner came to know about such wrong mapping, my lord, Then the petitioner filed a writ application, my lord. If your lordship,
You go to the permanent lok adalat.
Right.
We are giving the direction. You file an appropriate application before the permanent lok adalat for correction of the map.
Right.
And the map should be prepared in accordance with the terms of the settlement.
Settled.
All right. But Mr. SSK Naik and counsel appearing for the appellant. The order dated 23rd March 2023, delivered in WPC number 3803 of 2023, caused by a learned single judge of this court, has been challenged. In terms of the compromise petition, pre-litigation dispute has been resolved by the permanent lok adalat, permanent and the continuous lok adalat Vadrak, under PLA case number 31 of 2014. Salutary grievances conversed in the writ petition is that the map that was drawn was not in terms of the terms and conditions of the settlement. Stop. But the learned civil judge has declined to interfere the order of the permanent lok adalat. We do not find any infirmity in the said order. However, the appellant is given liberty to approach the permanent lok adalat and continuous lok adalat for making the due corrections in their order, due corrections in the map that is made part of the settlement by a survey knowing person.
Right.
The cost that would be incurred in the process shall be borne by the appellant exclusively.
my lord, can I pray, my lord? Something, my lord. Now the opposite, sorry, my lord, respondent number 6, who is the outsider? He purchased some land from one of the co-sharer.
We will
Now
not
he is
go into this detail, that matter, because it is a, you are not challenging the compromise deed.
No, I am not.
So if you do not challenge the compromise deed, it is merely a mistake. If there is any mistake in reflecting in the map, so we have given you liberty to approach the permanent lok adalat by a survey knowing man. They will assess it. If there is a mistake, that will be corrected. We cannot do it.
My lord, can I pray for status quo be maintained in respect
No,
of
no,
this?
no order. No. Then I have to issue notice to the other side, because his interest will be affected. You immediately take a certified copy and go to the permanent lok adalat. You make that prayer in the before the permanent lok adalat.
That may be liberty. Liberty.
No, that cannot be granted. You go to today. We have passed the order. In the last occasion, you took the adjournment.
My lord.
Right. So
My-
you take it. It will be uploaded today. You apply for this urgent certified
My-
copy.
oblige,
Urgent
oblige.
certified copy.
Deeply obliged.
Yes.
Item C.
Please,
Yes.
Yes,
Mr. Udgata.
the family court judge is not holding a judicial office and not a normal civil court. And accordingly, the order passed by the learned single judge is under Article 226. Your Lordship, for that matter, your Lordship may see the nature and function of the family court as discussed in the year 2011 Supreme Court 848 and the memo of citation that I have given on earlier occasion.
You produce these copies with your notes of citation.
Yes, madam. Last date I have given.
We have no difficulty to understand regarding whether the family court is a court. It's a court.
It's an inferior court because it's at the trapeze of the court, but not a court by itself.
And what order are you challenging?
I'm ordering, my lord, in fact, I have filed an application for a conciliation proceeding. That was rejected. Against that order, I came before this honorable court. And at the time of, I have pleaded about the case was transferred from Rajasthan to Jharsuguda. I have pleaded that. Then the order and date have been given. At the time of interim order, the Honorable Court taking into consideration the Rule 18 of the Family Court rules had not been followed, because in the case of the absence of the party, the conciliation officer has to approve the parties concerned. That having not been followed, the court granted interim stay, and the Honorable Court said that short returnable date to be fixed. The requisites was filed in time. Notice was they appeared, they did not file any counter letter. In the meanwhile, the trial court written a letter to the Honorable Court saying the party has suppressed the fact of the Honorable Supreme Court directing that within a period of 6 months this has to be disposed, endeavor to be made to dispose of the 6 months. That having been suppressed, so that was brought to the notice of the Honorable High Court, vacated the stay, and the counter was filed. There in the counter, nowhere the allegation about the suppression has been made. In the count, no vacation of stay has also been filed. And the Honorable High Court thereafter, at the time of final proceeding, at that time, of course, the order was submitted.
First come to the Supreme Court order.
Sorry, my
Let me see the Supreme Court order.
Supreme Court order. That extra copy actually. नहीं की थी थोड़ी रही ना नहीं थोड़ा फोटो गाड़ी जल्दी जानी है That was filed in the my lord before the signature that is there in the record, my lord.
We are not getting it. We are trying to search out whether have you filed.
Annexure 5, sorry, my Annexure 5.
Annexure 5?
67, 68.
Okay. It was given only the 4 weeks time. Just come to this judgment.
Supreme Court order, my lord.
Yes, last paragraph.
68, last paragraph. Considering the facts and circumstances of the case, this transfer petition is allowed. The transfer court shall forward the papers of the divorce petition within a
4
period
weeks.
4 weeks. Since both the parties are medical professionals, the transferee court shall permit the parties to appear through virtual mode or at least through their respective counsel till such time the trial commences and their appearance becomes necessary. The transferee court shall endeavor to dispose of the case within 6 months. Then you will also may see my pleadings at page 17. Page 17 of my writ application. That is Annexure 1. Paragraph 4.
Yes.
That the petitioner respectfully submit that thereafter on a transfer petition filed by the petitioner being transfer petition number so and so, the Honorable Supreme Court by order dated 28/7/22 transferred the said petition for divorce filed by the opposite party in the Court of Judge Family Court Jaipur to the Court of Family Court Jharsuguda. the petitioner gave leave to refer to the said order of the Honorable Supreme Court at the time of hearing of the writ application. At the time of filing of writ application, I have filed, and this do not amount to suppression, my lord, because in a decision in 2004 Supreme Court, in the memo of citation that has also been filed in page 61 to 66.
You meant to say that no order from the Supreme Court went to the transferee court?
Sorry, my lord.
No order of the Supreme Court was transmitted to the transferee court?
I'm sorry, my lord.
You mean to say that no order of the Supreme Court was transmitted to the transferee court?
Order must have been transmitted. That I do not know. Must have been transmitted. But in the impugned order, the trial court has not referred to that Supreme Court order.
No, this is a matter of fact.
It has been. It must have been.
So how the trial court can reflect that I am not aware of the order of the Supreme Court?
In the impugned order.
How the trial court can reflect things that way?
Because earlier this has been referred. Earlier this has been referred in the earlier orders, part of it. The trial court has referred to that Supreme Court order.
Where is that order? Now, what is the problem now? Tell us.
Problem, my lord, with regard, there is no suppression one. Secondly, the conciliation should be done at the beginning, because the objective is to go for a conciliation so that the family can be united, and there should not be an adversarial system in the beginning for adjudication. An attempt should be made for conciliation.
That was not done.
That was not done because 3 dates were fixed. What has happened?
Already we are issuing notice, re-admission notice, because admission can be challenged by the respondent. That
If
is
your
why.
lordship direct, I can serve copy because he was.
You can serve copy, that
And
will
serve-
be a
so that
short
short date can be fixed.
returnable date will provide to you. And you also examine the 6 months time that was given by the Supreme Court is not inflexible time. It says endeavor shall be taken to
Yes.
that. So endeavor means it is not an inflexible time frame. So the court can go on. Of course, you will explain that part if the other parties agreed.
And in any case, it doesn't affect the merits of the case.
All right. Heard Mr. Sanjeev Udgatha and counsel appearing to the appellant. The appellant has challenged the order dated 5/5/2023, passed by the learned single judge of this court in WPC number 3248 of 2023, Annexure 6 to the memorandum of appeal. Stop. Learned single judge. Your order dated date is, which order you have challenged? Which order you have challenged?
Challenge the annexure.
Not annexure. You come to-
Annexure 3, my lord. Page 60.
Annexure 3 or annexure 6. That is why I am confused. Come to your prayer in the memorandum of appeal.
Yeah.
You also compare. to-
Sorry, my lord. That's actually annexure 3.
Are you sure?
Yes, my lord. Page 60.
No, come to the annexure 3.
Annexure 3.
Annexure 3 also you see. This order was also passed with the learned single judge.
That order is challenged before this writ appeal. And the order that is challenged before the honorable single judge Is that is at in the writ application that has been annexed.
Just this is the order also of the learned single judge. Annexure 6, Annexure 3, both of the learned single judge.
Yes.
Which order you have challenged?
Challenge before the single judge mail and just submitting mail. Annexure 4. That is Annexure 4, page 46. Page 46.
No, it's all right. But which order are you challenging? Because Annexure 3 also.
Annexure 6, relevant order is, my lord, at page 35.
Right. But Annexure 6 starts from.
That actually Annexure, instead of Annexure 6, your lordship says Annexure 3.
Annexure?
I'll write, I may be allowed to correct Annexure 3. Annexure 3, the order of the single judge.
Sorry, the Annexure 6 also the order of the single judge. In the same writ petition number.
Oh, sorry. Annexure 6, page 69.
Oh,
I'm sorry, man.
page 16. Then what is Annexure 3?
Annexure 3 is true copy of the onwards 60. Annexure 3. Annexure 3 in the whole level. Oh, that is interim order.
Possibly the learned single judge?
Interim page. No.
So this is not the Annexure 3 you are not challenging.
No.
Because this interim order, life of the interim order is over now.
No, that
All
I'm
right.
not telling.
6. All right. Mr. Udgata, that little bit of browsing of the papers in the home is required
I'm
sometimes.
sorry, I was only concentrating on the maintainability, so in aspect of this.
By means of the said order, learned single judge has dismissed the writ petition for suppression of quote unquote suppression of material facts before this court. Stop. So Mr. Udgata Learned Counsel has submitted that in the record of the family court, the order dated 28/7/2022 is passed by the Supreme Court of India in transfer petition within first bracket civil number 2226/2019 would be available. Stop. You file next day that these are available. You make a scrutiny of the lower court record, whether that order is available in the records or not. Stop. Admit this appeal to be heard on merit. Issue notice. Call for records of WPC number 2348 of such and such of 2023. Stop. Notice is made returnable on 13/8 is all right. 13/8/2023. The issue pre-admission notice. 14th August.
IA for stay for the proceeding.
Just a minute. Let us pass the order here. IA is for what? Stay.
Stay.
What will happen? The proceeding is going on.
Yes, ma'am. Yes, madam. He is now posted it for cross-examination of the respondent.
All right. Of the steps for service for service of notice on the sole respondent shall be taken within 5 days from today by registered post with AD. In IA number 2594.
2594.
2594 of 2023. Heard Mr. Sanjeev Gatal and counsel appearing for the applicant. This is an application for staying the further proceeding of, what is the proceeding number? You only want the deposit should not be insisted upon.
That is actually after the final order is passed in the trial court, that should, at that time, deposit should have been made.
No, the 25,000 cost that has been imposed by the London single judge.
That has to be deposited after the closure of the proceeding. That is the order.
That is the order.
That's the order.
So what do you just come to read your prayer?
For the time being, I am not pressing that application 2593. 2594, your lordship may see 2594.
I'm on 2594. Come to the prayer.
We have narrated, therefore, this honorable be pleased to pass appropriate order staying further proceeding in CP case number 91 of 21 now pending in the court of.
It is 2594 according to you.
Last miscase.
Yes, I am reading last page. Page number 2. Prayer is at the bottom.
Page number 2, yes, my lord.
Some mismatch is there. You record and our records are not telling.
Please give the IA number.
There are two IA number. One is 2593.
Which
Another
IA do you want us to read?
state that is 2594. Last miscase.
Okay, this is clearly the appropriate order staying the deposit of cost pending disposal of appeal.
Clear.
That is the official record with this IA number that you are referring to. That is the official records you are reading. This 2594, your prayer is simply to stay the deposit of this cost.
So that means the other is 2593, maybe that state. Because
You have filed the IAs on the same day. While marking it, you must have marked it incorrectly.
Yes.
Must take up London Council. For this, just to make it 2593, huh? For staying the further proceeding of CP case number 91 of 2021 pending in the court of the Judge Family Court, Jharsuguda. So issue notice returnable on the same date. Steps for service on the opposite party shall be taken within 5 days from today by registered post with AD. Stop. Till the next date, the proceeding of CP number 91 of 2021 shall remain suspended.
Item 4.
Item 4, Your Lordship, I pray for an adjournment. May be taken up on Monday.
It may not be on Monday, it is Tuesday. 40 plus. Next date can be 17th of July. It will come.
17.
At the request of Ms. S. Das, London Council appearing for the applicant, let the matter be listed again on 17 July 2023. And Mr. Rath.
Hello.
Mr. D.N. Rath, London Council has appeared for this. All the opposite parties?
No, ma'am. Respondent 1.
Appearing for the respondent number 1. 2, 3, 4. You take note, we are not passing any order today. All right.
Item 5.
In order dated 15/5/2023, my lord.
15/5.
Order number 2.
Okay, yes.
Lordship got it. Lordship directed the additional government advocate is requested
Yes,
to
do you have any instruction?
My lord, I haven't yet received, my lord, I'll need some more
It
time.
was passed in 15/5.
My lord, I have intimated, but somehow it hasn't come. Short adjournment, I'll,
17th July,
my lord,
but no further accommodation
My-
tonight. At the request of Mr. T. Naik, additional government advocate. Let the matter, let this appeal, let this petition be listed on 17th July 2023 for enabling Mr. Naik, an additional government advocate, to receive the instruction in terms of the order dated 15/5/2023. Stop. Mr. S. Maulik, counsel, appears for the petitioners. 17th July.
Item 6.
May I please, my lord? I may submit that there are some defects. So may I be permitted to?
All right, let the matter be listed on 28th.
Because ODI annexer English translated copy has.
All right, you are fixing on 28th July 2023. Meanwhile, the petitioner shall remove the defects as identified by the registry. Mr. P.K. Mudoli, you are appearing for all?
Yes, my lord.
An additional government advocate appears for the opposite parties and advance notice. All right.
Item 7.
Has appeared for the opposite parties. Number 1 to 7. On advance notice. All right. Next.
Item 8.
May I please, your lordship? The petitioner challenged the constituency of Rule 4 of the Group B, C, D, and Post repeal of Civil Special Provision Rules 2022. Similar matter, your lordship, fixed to 24th July.
24.
Just.
Well.
Mr. You are appearing, Mr.
Yes, ma'am.
Mr. M.K. Kunti. You need any extra copy?
One.
One extra copy of the writ petition be furnished to Mr. Konthial and counsel by the petitioner in the course of the day. One additional copy.
Yes, ma'am.
Similar order we are passing, returnable date is 24/7.
Yes,
Notice same, just to follow this order.
Obligation.
Item 9.
May it please, my lord.
Yes, sir.
This matter, item 9 and item 16 are identical matter. Here the moot question, my lord, is content is running page 25 of my writ application, which is the prayer part. Here we say that once a person has a legal grievance and has moved a particular forum, legal forum, simultaneously during the pendency of that, he cannot move to other parallel forums, even if such forums may be available for similar relief.
There requires a comparison, learned counsel.
So,
That what cause they are in different court. You have to show that is your primary duty because broadly the principle of sub res judice. That cannot be because you know the Sub-res judicata only thing is the different parties. But here is according to you, the same party is moving to different forums on the same cause. If I have correctly understood you, that is the grievance of yours. So that requires a comparison, whether it is the same cause or there is a different cause, whether it is the same prayer or there is some different prayers are made in the subsequent or the parallel legal action.
Will my lordships bear with me for a
Yes.
minute?
Yes.
Here in this case, there are huge number of customers with a promoter company, a real estate promoter company. The directors of those companies were arrested and proceeded against by the crime branch. Thereafter, they obtained bail from the Supreme Court. The Honorable Apex Court directed deposit of the entire amount which they have collected from their customers
Yes.
in the registry of the Supreme Court. That was done. On being satisfied, the interim bail that was given earlier upon a deposit of 10 crores, the total liability was 69 crores. The bail was regularized. Then there is a state act, my lord, called OPID Act. Now, the Honorable Apex Court ordered transfer of the entire amount to the OPID court here and eventually to arrange for disbursement of this amount to the respective customers under the scheme of the Act.
Yes.
This has been going on for last 4 or 5 years. The additional district magistrate Cuttack is the competent authority under the OPID Act
Yes.
who is holding the money
Yes.
to disburse to the customers. Now, that mechanism is not functioning. Since it is not functioning efficiently as is desirable, customers are straying away to different other forums like the RERA, like the Consumers Forum,
Yes.
and getting orders. While we, the builders, we have already washed our hands off by complying with the order of the Supreme Court by depositing the entire money.
What is the Supreme
And
Court order?
there is an order
Have you
that
annexed the Supreme
that
Court
money
order?
be refunded.
Where is the Supreme Court order?
Like,
Space 40. And it's to a space 40. Transfer. Page 41.
running page 41 of the writ application allowance. May I read out, my lord?
Read slowly, please. There is no fascination in there.
Mr. L. Nageshwar Rao.
Shall be transferred to the trial court. Mr. L. Nageshwar Rao, learned senior counsel appearing for the petitioner, seeks permission to withdraw the petition for directions being set for the liberty to move the trial court. This is pertaining to some set off matter. While depositing the 63 crores, there was also an application that already 13 crores have been settled with the customers and only 50 crores is liable to be refunded. So the apex court said, let that matter be decided by the trial court.
What you said, is that correct or just the opposite? Because they say balance amount is 13 crores. So that will be deposited.
Yes, my lord. But
Okay.
I am not there.
Okay.
The entire 63 crores,
Yes.
along with the interest, which is now touching about 90 crores,
Is there with the trial court?
is lying with the mechanism of the government. Let notice be issued.
That can be. Problem is there is two problems that I'm facing. That we do not know who are the depositors.
Pardon, my lord.
We do not know who are the depositors. That they will, I mean according to what you call the customers. we do
OP
not know
number
who are
one
the
is
customers.
one of the depositors who had gone to the RERA and obtained an order.
Okay. First of all, there can be the Supreme Court order. These are all.
There are similar so many litigations pending, and they are all posted before the Honorable Chief Justice's bench for 8th of August. 8th of August.
So one thing we can do, we do not pass any order. You do this matter mention on that date. We are not passing. We only observe that your statement that the similar other matters are before the bench of the another bench. Just give that order, copy of the order, and you mention and get those matters listed there. Because there are certain issues, Mr. Bakshi. The issues this is a condition of the bail. There is the money you have realized from the customers. That is only that money as a condition of the bail you are asked to deposit in the Supreme Court, and Supreme Court has transmitted that amount to the OPID court at Cuttack, the special court. Now you are just demonstrating that the problems is rooted in non-disbursement of that money to the customers. This may not be the case, because the RERA Act provides certain other things. That is the element of the compensation in the form of interest, in the form of other interest, the little bit of damage the customer suffers. So even if someone accepts that money, because Supreme Court order was not passed with taking their consent, that he has passed such order. It is a matter of granting you the bail so that the customers are not suffered adversely. But their interest doesn't end there. Right? So there can
That's an exemplary
there
order.
can be multiple of the litigations.
That order of the Supreme Court is an exemplary order. Even before the OPID mechanism was in place in the state.
No. Supreme Court's order is very simple.
Court.
There is no complexity to understand the order. Order is very clear. That is the amount you have realized from the customers.
Yes, ma'am.
And the customers are now filing criminal complaints against you on that basis. And you are arrested, you are not getting the bail, you have come to us, deposit the entire amount before us. 13,000 was the remainder of the amount that was asked to deposit. You have deposited, the money was transmitted by. But the interest of the customer doesn't end there.
There is no rival contention as regards
that will
the
be decided by the competent forum. This will be decided whether there remains any other interest to be addressed to by the legal forum or not. That cannot be decided by the Supreme Court, because those parties are not before the Supreme Court. And it is simply as a bail condition. Then Supreme Court has made an additional direction to the court concerned to identify those persons who have deposited that money and refund that money. Part of their grievance is addressed. But what about the money was kept by these people for such a long time? The money is its own value. It has been corroded by not delivery of the service. So they have certain multiple interest also there.
My lord.
Already I am passing a simple order without today making any observation. But this is my preliminary observation. We are not passing any order. Just give me the copy of the order. You mention all those matters on 8th. it has been stated by Mr. Amitav Bakshi and counsel appearing for the applicant that the similar writ petition involving the identical disputes has been posted on, shows it is 7th February. You are saying something at 8th of August. This is not the order perhaps. It shows it will be listed on the 7th February.
Yes, my lord. This is
My lord, there is an order dated 5th of January 23,
Right.
wherein the status of disbursal was required to be notified by the government to this honorable court. To that effect, there is an order.
No, that is there, but
And the state undertook to provide the disbursal status to the court by 7th of February 2022. I'm passing on that order.
Other
to you.
cases, perhaps some
no,
instructions.
I am reading that order, 5th of January 2023 order. No, but your associate counsel was mentioning that the similar other matters are fixed on 8th of August.
8th of August.
Where is that order that matters are, we can ask on your statement we can make, but it will be difficult if exactly the date is not on the 8th August.
8th of August.
Are you sure that?
8th of August.
8th of August, yes.
You, Mr. Mahathir, are you sure?
Because in those cases also, we have obtained certain instructions. I was doing that case on the Chief Justice.
Instruction.
And all the matters can be tagged off. Because similar question, whether that.
So
amount-
why don't you mention one case number which is posted to 8th August? Mr. Bakshi, do you have one of that is one of the case numbers which is
It is
you-
10681.
This one?
Pending list, he will supply all the cases.
No, if you mention one, it will go along with that.
What you have taken?
In these two present writ petitions,
They are posted to 8th.
we are
It
raising
has been posted in the
a question
on 8
whether a
2023.
litigant, a
Stop.
bona fide litigant, can
Uh,
for the same of
A order, an order,
grievance, move multiple
copy of
agencies.
the order dated. It appears from
That
the
is the-
order dated 5/1/2023. That the similar writ petition, one of the
That's
similar
my
writ
prayer
petition
in this
is WPC number 1061681 of 2022. Mr. Bakshi has, council has submitted that this writ petition may be allowed to be tagged with this, that batch of writ petition stuff. In view of the above statement made, let these matters be listed before the appropriate bench where the analogous matters are pending. Stuff. If it is analogous matters are pending. Just we have directed that matters will be tagged with those matters.
Yes.
Are they there? 8th August stuff. Place this petition on 8th August 2023.
16 shows.
So the same order in item number 16 also.
Item 16 also.
All right.
Much obliged, my lord.
To make a mention, my lord, pardon to make a mention, my lord, item 7, due to net problem, I could not submit, my lord. Item 7, my lord, due to net problem, I am from Puri VC, my lord.
That your order passed now? We have adjourned the matter on 3rd August. Why don't you appear on 3rd August?
My lord,
It's appeal, so there may not be that urgency. So you just address us on 3rd of August. We have fixed it on 3rd of August. All right.
my lord.
Item 10.
May I please, your lordship. My lord, this matter relates to public interest litigation. The petitioners are elected representatives of 3 gram panchayats. Who are the petitioners in this case? They have made prayer in this writ petition to exclude the jungle and government land from acquisition on the ground that the jungle is their life and livelihood. Your lordship kindly see annexure 5.
No, just there can be the 2 kinds of forest, Learned Council. That things are not that simple. There is a one forest called the reserve forest.
My lord.
And one forest called is a protected forest, right? Under the Indian Forest Act.
My lord, they are going to acquire reserve forest as well as protected forest.
These
Under
cannot cannot be acquired unless a clearance given by the Ministry of Environment, the central government.
Central government, my lord.
They have obtained that permission. Have you inquired into this matter?
My lord, whether they have obtained permission or not,
We will find out.
I am sorry to say that I am unaware of. But my lord, so far as I have obtained instruction and the document which is available with me, it reveals that that is apparent on annexure 3 at page 23, my lord. Your lordship kindly see.
Yes.
Village Banjari, that is a Gram Panchayat. Private land 379.806 acres of land. Forest land 85.070 acre of land. Government land 201.46. Total 666.336 acres of lands. Another Gram Panchayat, my lord, that is serial number 5. Kudaloi. Private land 70 acre. Forest land 96 acre. Government land 23 acre. Another Gram Panchayat, my lord, that is serial number 6. Pipili Mala. 534.394. Private land. Forest land 115.500. Government land 294.617. Total land 944, my lord. Whenever the petitioners, those representatives of 3 Gram Panchayats came to know about the acquisition of land, they
Where is the
made
acquisition notice?
they made application.
Where is the acquisition notice?
Acquisition notice under annexure annexure 4, my lord. That is in Oriya, my lord. That is in Oriya.
What does it? Just you translate it? Informally translate.
My lord.
That is not base Sangrakshana, de-reservation case. That is not acquisition. Your lordship can see, my lord. Base Sangrakshana case number so and so. That is de-reservation.
After pre-reservation, it has been done.
तो जमी सर्वसाधारण खाताभुक्त रास्ता की
But council, why don't you file the translation of the Oriya text?
I will file a translated copy.
All right, file it. It will take up after few days.
My lord.
After few days, we will take up this matter.
My lord.
Let the matter be listed on 17th July 2023. In the meanwhile, Mr. Arin Prusti.
My lord.
And counsel appearing for the petitioners shall file the translated copy of the Oriya text. Translated copy of the Oriya documents containing Oriya texts. Stop. Let the matter be listed on 17th July, no? So Mr. DK Manthil and additional government advocate has appeared for the opposite party's number. You can also appear for pollution control board.
No,
Opposite party number 1 to 5, 1 to 5 and
I cannot appear for IDCO. even
6. Stop. 1 to 5 and 7. Stop on advance notice. All right, 17 by 17 July you file these translations.
Item 11.
May I please address? I may pray to adjourn the matter till last week of July, and till then I will remove the defects also.
Where the matter will be listed on 11th of August. Last week was the 28th July. 11th of August 2023 at the request of Mr. D.K. Ratho and Council for the petitioners. Appearing for the petitioners.
Item 12.
May I please? Here the petitioner is president of
Yes.
Orissa Vikalanga Bancho, an organization meant for the development of the persons with disabilities. And the limited prayer of the petitioner, my lord, irrespective of the scheme formulated by the government of India, state governments, and irrespective of the mandate by the Act, that section 37 of the Persons with Disability Act 2016. Now the benefit as has been provided, specifically 5% reservations that have not been given to the disabled persons. This is my entire grievance. In that respect, I have given some documents.
All right, we will examine the matter. But you are Mr. D.K. Mahapatra, Land Council appearing for the petitioner. Petitioner is an individual interested in the welfare of the physically challenged person. No, these actually he is moving this application for the physically challenged person.
Yes, challenged person.
Physically challenged person. According to Mr. Mahapatra, that under the Prime Minister Awas Yojana, the 5% of the houses, assistance for construction of the houses to be allotted to the physically challenged person within the meaning of the Persons with Physical Disability Act, Persons with Disability Act. This is in 2016 Act.
2016 Act.
2000. Do you have the copy? Just
Yes,
give
yes.
me.
Section 37. And also the government letter is also there. Also kindly see that is annexure 2. But you just a glance annexure 2. Annexure 2, page 29. That is also the government guidelines. And
all right.
29, page 29. Referring to
Under
section
the
37 of
Rights
the
of the Persons with Disabilities Act 2016. Stop. In this regard, Mr. Mahapatra has made a reference to the communication made by the Ministry of Rural Development to the principal secretaries of the Department of Rural Development of the various state governments and UTS. So from that communication, it appears that that in the scheme, %5 of the beneficiaries at the state level should be from the persons with disabilities, and within that 5% allocation, the women will be given further priorities.
Then what I pray, Lord, kindly just the another next page 30. That is also the government decision. State government decision that is there.
Yes.
This 30. The relevant portion page 31. Referring section 37 of the Act.
So on the same point, reference has also been made to the communication dated 2/8/2018, Annexure 3 to the writ petition. And
the last is page 60.
Page 60.
Page 60 is the government decision, the recent decision of the government. That is PR departments. Page 60 Annexure 8. CMRA 5% reservations.
And the communication dated 6/2/2023, Annexure 8 to the writ petition. Stop. Issue notice returnable on 24th August 2023. Since Mr. P.K. Mudali, an additional government advocate, appears in web's notice for the opposite parties, no formal notice is called for. However, Mr. Mahapatra and counsel for the petition, one extra copy of the writ petitions to Mr. Mudali by tomorrow. Stop. The registry has pointed out some defects in the writ petition. The petition is directed to remove these defects within 5 days from today without fail, and for that purpose, no further accommodation will be made. Stop. Further, we direct the opposite parties to make a statement as regard the allocation of the 5% of the 5% of the houses, assistance for construction of houses under Prime Minister Awas Yojana to the physically challenged person as per the policy framework as noted above. So, whether the opposite party shall make a tabular statement showing the district-wise allocation of the assistance for construction of houses to the physically challenged person. Stop. By an affidavit, those data shall be produced before us. So, if there is any lapse, that also should be reflected so that this court can have an idea how the policy has policy of allocating 5% of the housing assistance for 5% of the financial assistance for construction of the houses under Prime Minister's Awas Yojana is being implemented in the state of Orissa. Stop. Such affidavit shall be filed by the next date. A copy of this order be furnished to Mr. P. Muduli, London Additional Government Advocate, by tomorrow.
In fact, on their representation, on the representation of the petitioner association, matter was taken up by the government and detailed.
In the short affidavit you reflected, we only note this, these are the 5% part is a part
That
of
is
the.
there in the record. That proceeding is in the record, page 55. Starts from page 53.
So, these are the communication, but these are some opinions are there, but we want the statistics.
Yes.
If it is not district wise, how you have done it? Because the physically challenged person may not be found in some district sufficiently who are entitled to get these houses.
District-wide data must have been there.
So you show that why you could not implement.
Item 13.
I may please your lordship. I am in virtual mode, my lord. The public interest litigation filed by the petitioner against illegal construction over the government land, which was specifically earmarked for the Jubak Sangh, for which the petitioners have made a representation or annexure fee to the collector through registered post, that is at annexure 17, and the proof of postal receipt as annexure page 19. Till then, no decision has yet been taken. The lordship may kind of glance at annexure 1, page 13. That is the Odia I may take help, my lord Justice Rath. Plot number 125, page 13, page 125. That is earmarked for Jubak Sangh.
You have any interest over that land? You have any interest over that land?
The Jubak Sangh, the community purpose that has been earmarked for village community purpose. So opposite partner 5 and 6 adjacent land, they are unauthorizedly constructed over the land. So entire villagers will lose their right if any fund will allocated for the construction of any community hall or other purposes.
Community hall is for the villagers.
Villagers, man.
So why are you saying villagers will lose the right?
They are encroaching that land to 5 and constructing the land over the plot number 125. 125 plus 13 may kind of glance, plot 125 for Jubak Sangh. 5 and 6, the owner of the plot 126 adjacent, they are encroaching the land. Our grievance that 125 should be encroached. That's why I have made a representation to the collector and all authority under Annex 3, page 17. Still pending.
Mr. A. Mahathur, when counsel appearing for the petitioner has stated that illegal permanent construction graving the government land has been going on. Of the said construction is on the land comprised in plot number 1 to 5, khata number 91. What is the name of the village?
A village called Kanhaipur.
Of village Kanhaipur.
People at page 18 I have just described in the representation.
Stop. The extract of the khata has been, khata annex 1 to the petition has been enclosed for our perusal. So, Mr. Mahanti, Land Council has submitted that the petitioners have expressed their grievance to the collector Kendrapada and urged him to take the appropriate action for protection of the government land. So, but no action has been coming forth. As the petitioner has filed this writ petition, urging the relief which reads as under quote. It's not quote. Is under
Annexure 3, ma'am.
The construction by the opposite party number 5
and
over the
6.
government land in plot number 125, kata number 91 of Mauja, Kanchipur, in the district Kendrapada. You have to write and is a Kanhaipur. Somewhere you have written just Kanhipur, huh? You have typed Kanchipur, in the district of Kendrapada shall not be declared illegal and rehoused in law. Stop. According to the petition, the collector shall not allow anyone, including the opposite party number 5, to construct any building over the government land.
5 and 6.
In the prayer, you have written only opposite party number 5.
This writ petition is disposed of in the direction to the collector Kendrapada to inquire into the allegations made in the representation dated 29/5/2023 under Annexure 3 to this writ petition and to take appropriate action. If it is found that opposite party number 5 is in occupation of the government, state government land, or taking preparations to construct building or semi-permanent tenement, he shall be given reasonable opportunity to lay his case, to lay their case. They shall be given a stop. Whether it's effective or not. So if it is found that any construction being made unauthorizedly over the government caste land, that shall be immediately stopped. Stop. Stop. Accordingly, the writ petition stands. There shall be no further direction. Appropriate order shall be passed by the collector Kendrapada within 2 months from today. But so far the stopping of illegal construction is concerned, he shall act forthwith. Mr. D.K. Mohanty, Learned Counsel, has appeared for the opposite parties number 1 to 4. 1 to 4. A copy of this order be furnished to him for onward transmission.
Yes.
All right.
Obliged. I'll oblige.
Item 14.
Yes.
This is regarding lordship's challenge is for the validity of the antenatal order 2009. And this all the matters are slated
For 17th August. Yesterday, those bad matters.
Why have you constructed the infrastructure? Why are you not studying the medical college?
Well,
there is the plan made directing the government to take.
This is 14.
This is item 14, I think.
Let's see 14. This is
a challenge that virus of the 2009 order.
no. This is other.
These are the matters we are hearing. They're like that, those matters.
Yesterday's matter.
So it will go to that date only.
17th.
We issue notice.
Yes, ma'am.
Heard Mr. Chandrakant Naik from council agreeing to the petition. By means of this writ petition. The petitioner has challenged the validity of you are here challenging the 2004.
9, that's it.
Come to the relief where have you challenged the 2000?
Page 22. Roman
Validity of Odisha within bracket aided colleges. Order 3, validity of order 3 of Orissa within bracket aided colleges, aided junior colleges, and aided higher secondary schools. Close the bracket. Grant in aid order 2009. With particular reference to order 5, clause 1, 2, 3, 4, 5, 6. Stop. There are some other ancillary reliefs as have been asked by the petitioner. Issue notice. Since Mr. M.K. Kuntial and council appears in Webb's notice for the opposite parties number 1 and 2. No formal notice is called for in respect of those opposite parties. However, the petitioner shall take steps for service of notice on the opposite party number 3 by registered post with AD within 5 days from today. Stop. As it has been informed to us, the writ petitions challenging the provisions of the grant in aid order is fixed on 17/8.
Notice to go opposite party number 3.
That you have
Since
directed.
the Lordship in other matters, since the validity of the order is under challenge, it's formal party or governing body. He has nothing to do. Governing body of the college.
No, but you have made them parties, so we have to issue notice. We do not know what stand they will be because they are maintaining the relation with the government. They may support the government stand. Where you deprive them? On 17/8/2023. With the analogous matters. All right.
Item 15.
Infrastructure of MIMSAR is ready since 2018.
Yes.
By spending 500 crores. The government has given free of cost 20 acres of land. And the Honorable is a known area for polluted so far as pollution is concerned. It is in index number 7 of the country. So after my construction, when the infrastructure is ready, in all respect, they are not strategic function. It has not yet started.
You take instruction. We are not issuing notice directly in this point out. And it says General and Council appearing to the petitioner. Having perused the nature of allegations As made in this writ petition, we request Mr. P.K. Muduli, an additional government advocate, to take instruction. Stop, let the matter be listed on 28th of July, 2023.
28th of the
Stop.
July.
Then on that they will decide on the basis of their instruction whether to formal notice would be issued or not. Yes.
Item 17.
By Monday, my lord, on behalf of Mihir Kantar. Pray for adjournment next week. On behalf of Mihir Kantar.
Mr. D.K. Naik, Learned Counsel, appearing on instruction of Mr. M.K. Roth, Learned Counsel with the petitioner, prays for a short accommodation. So the prayer and allowed, let the matter be listed on 14th August, 14/8/2023. Paul?
Item 18.
May I please notice? Here the petitioner filed the PIL with the president of the district disabled
Mr.
Federation.
Mahapatra, there's a lot of defects.
Millet.
You just have a glance at a lot of defects have been identified that.
In fact is you have not given any representation in this regard to the government. So
Now I am-
PIL rules provide that you should give.
Millet, here I am questioning the very validity of the orders. That is contrary to Supreme Court judgment. Let's see, kindly see, kindly just what I'm submitting. Let's see, just a glance, page 47. This I am basing on the circular of the government at page 47. Referring to the Honorable Supreme Court judgment. Let's see, kindly just a glance, page 47. How it is contrary. Page 47.
That we are pointing out that you have not also supplied the legible copy of page 62. According to the registry, 62 cannot be read.
Millet, I will 62. Page 62 is not so much relevant. Also, we can ignore that matter. Or I can also permit you to file after tomorrow or within 1 or 2 days. But so far, the
It will come on 17th of July. File it in the meanwhile. 17th July.
17th July.
Let the matter be listed on 17th
Yeah,
July.
let's say I take 18th July. 17th, I have some personal. I have some personality for 18th. 17th, I have some personal.
18th July 2023. Meanwhile, the defects as identified by the registry shall be removed. Mr. D.K. Mahapatra, counsel has appeared for the petitioner, and Mr. M.K. Kuntia, learned additional government advocate, has appeared for the opposite parties. I think you can appear for all the opposite parties.
Yes. These are all statements.
On advance notice. Okay. You just change it. We'll hear on 17th.
Item 19.
Mr. Mahapatra, that page is relevant. It's a clarification of the government. So you give a typed copy. if it
Don't I
is-
give? I cannot say I'll give.
And some other defects also
Yes,
try
yes,
to
yes, I'll
remove.
give. So for I'll try.
I may please your lordship. This PIL challenges the operation of two sawmills operating near the reserve forest areas in the town of Baripada, your lordship. Which is contrary to the law itself, which states that no sawmill shall be operational near radial distance of 10 kilometers near the reserve forest.
Contrary to what? The Supreme Court judgments?
No, your lordship, contrary to Odisha Sawmill and Sawpits Control Act 1991.
That is the outcome of the Godavarman's case.
Yes, your lordship.
Prior to that, this rule is there.
That rule was there?
Yes, 91.
Okay.
Godavarman is 1995.
95, right. Where is this rules? Have you annexed those rules?
I have the book with myself.
Book?
I have the book.
Not even in the writ petition, you have reproduced the relevant part?
No, your lordship, not in the writ petition.
What is the book?
It's a manual wherein
Which-
the act is there.
Which is the manual, name of the manual?
Odisha Forest Manual, Your Lordship.
You have the Odisha Forest Manual.
Mr. Mudili, he says it's near the reserve forest.
That is his allegation. And in fact.
He's not
this-
given any material, supporting material.
No.
They have attached your Lordship, I have attached the map.
Jalaram sawmill. Annexure 1 series, don't.
What is the page here? What is the name of the rules?
Odisha Sawmill and Saw Pits Controls Act 1991, page 685. Your Lordship.
Odisha Sawmill and Saw Pits Control Act 1991.
Yes,
Am I
Your
correct? The 903 is a different kind of a manual. 903.
Section 4 of that act. Your Lordship.
Yes, which
Section
provision
4.
you refer to?
Section 4, proviso of subsection 1, Your Lordship. Provided that no person shall establish or operate any sawmill or saw pit within a reserved forest, protected forest, or any forest area, or within 10 kilometers from the boundary of any such forest or forest area.
For which?
But
Have you
in this-
complained to the authority?
I have already complained, Your Lordship.
Well, Annexure 3,
It is in page 33, Your Lordship.
Annexure 3 series.
Annexure 3 series.
Competent authority is the opposite party number 4, DFO. Lordship, may
All right,
direct
you
the
just
DFO.
inquire into, we are issuing notice. Let them make a physical verification and come with a short affidavit. You are Mr. Sahu,
I'm SS Bhuya, Your Lordship, Saurav Suman Bhuya.
or you are not on record.
Then I'm appearing on behalf of my learned senior, Your Lordship.
Mr. S.S. Buyal on it. Counsel appearing on instruction of Mr. Vivekananda Buyal at counsel for the petitioner. A serious allegation has been made by the petitioners for flouting the section 4 of Odisha sawmills and saw pits, saw SAW, saw mills and saw SAW pits, PITS, pits within First Brigade Control Act 1991. Section 4, proviso to section 4 stipulates that no person shall establish or operate any sawmill or saw pit within a reserved forest, protected forest, or any forest areas, or within 10 kilometers from the boundary of any such forest or forest area. According to the petitioner, the opposite party's number
6 and 7.
6, 7, and 8, I believe.
6, 7, and 8, Your Lordship.
6, 7, and 8 have been operating.
Mr. Bhuya, those representations you have given, one you are saying they are operating without license. Look at page 31. There you are saying 2 licenses have been given on rehabilitation basis.
Yes, Your Lordship.
So what is the meaning of giving a representation with incorrect facts?
Your Lordship, as these were drafted by the villagers itself.
Is that an excuse?
No, Your Lordship, it is
In the
not. an
PIL, you
excuse.
give contradictory facts and then you say the villagers did not know. Villagers are the petitioners.
They do not have the proper environmental clearance, Your Lordship.
I'm
That
very
is what
sorry.
they're trying to say.
31 says they have license and the other annexure says they are operating without licenses.
No, Lordship, the license were granted under the rehabilitation scheme. But the area of operation where it is granted, that is what I am challenging, Your Lordship, as it is clearly contradictory to the law in this.
They have to shift from this prohibited area.
No. Under the scheme, it is there. Give the correct facts. Carelessly
Just
they will
what
find
the last are operating 2 sawmills within the prohibited zone. Stop. If- Stop. And it has been also alleged that the two sawmills which are named in the writ petition have become instrumental in illegal wood logging and wood laundering.
What? No, wood laundry. Wood pending, I can understand. Wood laundry.
Transmission.
One of the-
In laundering, causing the loss of trees from the Simlipal Reserve Forest within Meghalaya National Park and Hathikot Reserve Forest and Hathikot Reserve Forest and Manchabandha Reserve Forest and also from the village forest areas. Stop. Issue notice returnable on 27th of August, 28th of August, 2020. 20th is a Friday. 27th is Sunday. Mr. Moduli, we are issuing a short notice just to go and make a physical verification about this thing. You just issue short notice returnable on 28/7/2023. Stop. We direct the opposite parties.
P number 4, DFO.
Opposite party number 4 in particular to file a personal affidavit on physical verification vis-a-vis the operation area of the named sawmills. So at the time of verification, he also examined whether the proper license after environment clearance were issued, proper licenses in favor of the opposite parties number 6, 7, 8. So, and also further it will be indicated in the report whether the representation made by the petitioner on 17/7/2023 and 15/5/2023, 17/4/2023 and 15/5/2023 under Annexure 3 to the writ petition were taken for consideration or not. So invariably such affidavit be filed on the next date. After furnishing a copy of the affidavit to the counsel for the petitioner, Mr. P.K. Mudali, counsel, a free copy of this order be issued to Mr. P.K. Mudali, additional government advocate, such and such. The petitioner shall take steps for service of notice on opposite parties number 6, 7, and 8 by registered post with AD within 5 days from today. Within 3 days from today. Take today itself in the course of the day. Always.
What is that earlier writ petition you had filed?
Earlier writ petition we have filed against these sawmills only, Your Lordship, with the same said pair, but this honorable court disposed of the writ petition with a direction to submit a fresh representation.
Okay.
After submitting the fresh representation, petition as well.
Item 20.
Much obliged.
May I please, Your Lordship, my lord?
No. Mr. Bhuya,
Withdrawn because we have not submitted any representation.
That has been withdrawn to file fresh representation and thereafter seek for remedies. All right.
Yes.
May I please, Your Lordship, Matter, item 20. May I
Yes,
please?
what is your prayer in this public interest litigation?
Item 20, Your Lordship, unauthorized the petitions filed in the application.
Unauthorized encroachment.
Unauthorized encroachment of OP number 8, my
Have
lord.
you filed the representation to the
Annexure
appropriate?
1, page 8, in the postal slip by hand in the office in the my lord 11/7/2022, and the speed post on page number 8, Your Lordship.
Page kete?
Page Annexure 1, page 8, the representation. And the postal slip is page 27, Your Lordship, 7/11/2022. Initially, is submitted an representation before its office, my lord, and the authorities received the application on 27/7/22. Thereafter, the submitted an application by
All
the
right,
speed
heard
post.
Mr.
Parsuram Panda.
Panda, Learned Counsel appearing for the petition. This is a public interest litigation against the encroachment
The village road.
of the village road.
Beldandia Mauja.
Under the Beldhania Mauja district,
Basta Tahsil.
Basta Tahsil,
District Balesur.
district Baleshwar. Better details are available
Khata number 61.
in the record of rights as submitted along with the petition under Annexure 2. Stop. It is the case of the petitioner that he had filed the representation to the Tahsildar,
Basta.
Basta,
Annexure 1, page 8.
on when you filed the, on, which is the date on which you filed it?
11/7/2022.
On 11/7/2022, but.
Thereafter, on speed post on
All
7/11/2022.
right, 22, but no action has been taken by the Tahsildar for protecting the government road and its non-jury. Stop. Thereafter, Annexure 3 when filed?
Same application, same representation, my lord. Speed
All
post
right,
on
same
7/11/2022.
Submitted before the
And
sub-collector and collector Balasore, right?
sub-collector and collector both.
To the sub-collector and the collector Balasore. Consider the first one. Stop. Yeah, we heard Mr. D.K. Mohantil, an additional government advocate. Stop. We dispose of this petition by directing the
OP number 4, Your Lordship.
OP number 2 and OP number 4. Opposite parties number 2 and 4. To take appropriate action if required after film verification on the representations filed by the petitioner under Annexure 1 and 3 within a period of 2 months from the date when a copy of this order will be furnished to them. It is made absolutely clear if any individual is found on occupation on the government land, that person shall be given a reasonable opportunity of hearing. Stop. Stop. And if it is found that the government land has been encroached or there is squatting over the government land, the collector shall direct appropriate action in this regard.
Lordship, time, specific time, your lordship.
2
Yes.
months.
Yes.
Yes.
21.
May it please your lordship. Plus the petitioners, the members of Mahila Samitis under the jurisdiction of OP number 6. Their grievance, your lordship, may kindly come to page 23. Here the land has been earmarked for Mahila Samiti. Lordship, page 23.
Yes. Yes.
To support this, Milord's page 26 is the ROR that also Milord's specifically stated land is reserved for Mahila Samiti, Milords. Then your lordship kindly come to page 27. My lord.
Anganwadi center being constructed there.
Yes. Page 27.
That is for whose benefit?
Lord, benefit of the people.
Then
no, we are the specific land has been earmarked for Mahila Samitis. But they have constructed a AWC building over a plot, which is your lordship kindly available, page 22. And they have started construction. And construction is in a halfway. In the meanwhile, your lordship kindly come to page 27. Page 27 is a report by the Tahsildar to the CDPO seeking NOC from Mahila Samiti because the land is reserved for them. Without doing that, they are going on construction.
They do not have any specific right on the land.
My lord?
It has been only earmarked for the Mahila
Mahila
Samiti. It has not been allotted as yet.
No, Mahila Samiti. My lord, that has to be done for the purpose of the member of Mahila. Now, my lord, we kindly see these are two documents which earlier by virtue of work order constructed, and the now without any work order, without any authority, they are going on. This is my grievance.
What is your right?
Lord, because the land has been earmarked for the members of the Mahila Samiti.
The government in his own discretion thought that I will earmark that land for the Mahila Samiti.
My lord,
But
exclusively for Mahila Samiti.
Subsequently, no action has been taken. The land has not been allotted. To
No,
you, not the possession was handed
yes,
over.
that.
So that is why I am asking you, what is your right?
Lord, that is my right. Lord, derives from the ROR published in the name of this. And the OP number 6, your lordship kindly see, page 20, Lords, he also, the Sarpanch, himself also made representation, page 31, OP number 6. He is the Sarpanch.
The Sarpanch has nothing to do in this matter.
No, because that is within the jurisdiction of the Panchayat, Gram Panchayat, and the Sarpanch is the authority.
So was the allotment of the land or the...
Lord, that is the ROR and this is the report of RI. These are the two documents. Sarpanch himself made representation and requested not to make any construction. Page 31. That is also in English vernacular. Sarpanch,
English vernacular. What is Annexure 6?
Annexure 6, Millers.
Yes.
Annexure 6 is the Millers information we have obtained. Therefore, we have submitted the document.
Where is that information?
Millers 12/6/23.
Yes.
So on 12/3,
where is that information?
Millers, these information are Millers enclosed in the present petition in different annexures.
How?
Millers,
you have obtained through RTI. So what is that information which you have obtained?
Millers, these are the documents, annexure 1, 2, even Millers 4, 5, 6. These are the documents basing on which we could know that the land has been earmarked for the Panchayat Samiti, and that the building should, Millers, the shared land should have been made, or construction should have been done for the purpose of office of Mahila Samiti.
5 is not obtained through RTI.
Yes, Millers. So after getting this information, I have filed this. We made representation, all the members of Mahila Samiti. Sarpanch also supported us, and also he also agree with the.
Well, you have not answered my question. Where is your right to claim anything over that land?
We are the members of Mahila Samiti working different Mahila
Alright,
Samiti, not
government has only earmarked the land. Government has not allotted the land in your favor. You have not been given the possession.
the ROR is a symbol that shows the land earmarks for different purposes.
Well, we are for the time being, we are not contesting that fact.
Well,
but where is your right to come?
Only that is the right flows from the ROR.
No right, you apply to the
because
again.
as your lordship must.
We are directing the collector to find out a resolution to the problem because you have no right.
Lordship, the Gochar land, other lands which your lordship might be hearing.
These are the particular category of land. Earmark land doesn't in any category of land.
Yes, that is the kisam of land. We tell it the nature of land is this.
When the kisam can be created, when you have no right over that land.
Because the right flows from this ROR only. Nothing. I can develop the case.
Write something in ROR, right will flow from the ROR.
Yes,
ROR is a fiscal document according to the
shows the possession of the party. Who are in possession
for purpose of fiscal responsibility.
It is only for the purpose of the members of that locality.
Have you shown that you are in the possession of the land? Not a single line is in the writ petition.
No, we are not in possession, but if the land is earmarked for the interest and benefit of the members, women members of that locality, that land could have been constructed for the purpose of the office of the Mahila Samitis.
All right, Hearts. Mr. A.K. Mohanty, Learned Counsel, appearing for the petitioners. Petitioner. The grievance of the petitioner is enumerated in this public interest litigation is that a part of the land which was earmarked for Mahila Samiti comprising in plot number 355/1069, Khata number 327, Moja Venkatrayapur, Siripari, ward number 13, which was earmarked. No, the earmarked for the Mahila Samiti, no? Just read the line. Over the plot, over the over the plot, one Anganwadi center is being constructed today by filing an affidavit, additional affidavit. The petitioner has submitted 2 photographs, annexures 10 and 11 of the said additional affidavit. From those photographs, it can be gathered that substantial part of the construction has been made. So Mr. Mohanty Learned Counsel has strenuously argued before us, since the land was earmarked for the Mahila Samiti, the no further construction even by the government cannot be carried out. In our considered view, earmarking of a land doesn't confer any sort of right on the land. It only reflects the government intention of intention stop. Be that as it may, we direct the Collector Khurda to look into the grievance of the petitioner and to recalibrate the land earmarked for the Mahila Samiti. If necessary, some more land can be added for the adjoining government land. For this purpose, we direct the petitioner to file a representation to the collector Khurda within a period of 15 days from today. Stop. On receipt of such representation, collector shall make all initiatives to resolve the grievance of the petitioner. As we gather that the government has intention to allot some land in favor of Mahila Shamiti, which the petitioner presently represents. Stop. In terms of the above, this petition stands disposed of. A copy of this order we furnished to Mr. P.K. Muduli, London Additional Government Advocate, who has appeared for the opposite parties number 1 to 5. Stop. All right.
Well, they are going on with the construction.
It will not be stopped by us. You must understand that. This is also, we says the compensate you by adding the additional land. You cannot be that because you are also a public interest organization. Anganwadi, Anganwadi centers for whom? For the children.
What I beg to submit is, they have constructed a building. It is in the plinth level, and without going, completing the same, because the other document
previous building, Gochar land or not?
Resolution.
Gochar land, that is mentioned. That is the Gochar land. On
Gochar
land, no construction can be made.
Okay.
That is why probably that earlier construction must have been left out.
No, the resolution
has been selected.
Other document under Annexure 2.
We have observed that you do not have presently any right over that land. Sorry.
Because my law friend says that a Gochar land, there is a proceeding. In the proceeding itself, all the officers were present. Annexure 2 is the document.
All right, just right. The Mr. P.K. Muduli, London Additional Government Advocate, has informed this since the land was in the category of the Gochar land.
Yes, earlier land.
Previously. So no further action over the land could be taken up. So already go to the collector, file a representation, they will do it. Next.
22.
Please, your lordships. My lord, there is a defect that I have left. That is a matter of an application for PIL. I am permitted to write this in the court, my lord. In the PIL matter, we have prayed for a direction to the collector Kanjam to take effective steps to shift the 2 liquor shops from the side of the government primary school. It is in contravention of Road 26.
What is your representation to the collector?
Annexure 1 at page 8. Annexure 1.
I understand. Okay.
It is in contravention of Rule 26 of the Odisha Excise Rule 2017.
Have you filed the English translation of this?
No, my lord. It is in vernacular.
So, filed. He says no, we are saying yes. File the translation. As the matter will listed on 28th of July 2023 in the
28th,
28th July. In the meanwhile, the petition shall invariably file the English translation of the documents containing the English translation of the vernacular documents. Let Mr. D.K. Mohanty, Additional Government Advocate, has appeared for the opposite parties number 1 to 3. Stop on advance notice already.
That is the only liquor shop in the area, or there is one nearby?
2 liquor shops.
That's all. No other liquor shops there. Are you sure?
As for instance.
Your lordship knows how these cases are.
We have not passed any order, Mr. Mohanty.
No, I am not.
He will remove
Because
the
we find the more than 25 villages have submitted a representation. We want to know the content of this representation.
Yes.
And what action you have taken. You take also the instruction in the meanwhile.
23.
Please, your lordship. In this case, the petitioners, the villagers submitted their grievance before the collector under Annexure 3 that the misuse of the Gochar land in the village. There are 25 of gochar land in the village. Initially 5 acres has been allotted to a college, and that by applying the section 4 of the OGLS deregistration proceeding method. Thereafter, so many private organizations and government institutions has been to acquire the piece of the gochar land without any deregistration process, without any procedure method. There is a requirement of proceeding before allotment or specific earmarker to any institution. One temple took away 2 acres of land. One school and primary school constructed a house, their land, but occupied the gochar land as their boundary. That's why we have made grievance before the collector under Annex 3. The collector forwarded to the sub-collector. Thereafter, no action has been taken.
But your grievance is regarding construction of Anganwadi center and medical
No,
sub-center.
recent that I have demonstrated. Recent, the Tahsildar allotted 2 pieces of land before deregistration proceeding and permitted to construct the same. Before construction, before allotment, there must be a deregistration proceeding, and equal set of land has to be allotted to the villagers.
All right. Heard Mr. P.K. Satapathy, Lord Counsel, appearing to the petitioner. By means of this writ petition, the petitioner has urged this court to direct the collector Kotok to conduct an inquiry on the misuse of gochar land in Natkai village under
Nischinta Koili Tahsil,
Nischinta Koili Tahsil,
which is used for
and also to, and if found there is some unauthorized construction on the gochar land, but to remove the unauthorized construction
encroachment also.
on the gochar land. So it has been further asked that the collector Kotok shall also make an inquiry to illegal allotment of gochar land of same village, Napkati village, Tahsil, such and such. So after due inquiry, the such illegal allotment shall be cancelled. Stop. Mr. D.K. Mohanty, Learned Counsel, Learned Additional Government Advocate, appearing for the respondents number all the respondents except respondent number 9, respondent number 1 to 9. And submitted that the government doesn't have any inhibition to inquire into the allegation as made by this petition. So accordingly, we direct the collector Kotok to carry out an information whether the gochar land under the village situated in village Natkai under just the same Tahsil and has been encroached or any construction has been made on the gochar land and also whether there had been allotments made without following the dereservation proceeding. Stop the collector Kotok shall furnish a copy of this inquiry to the petitioner, which may be sent by a registered post in the address given in this petition. So, in terms of the above, this petition is disposed of. A copy of this order be furnished to Mr. Mohanty, Government Advocate, Petition Government Advocate. Stop urgent certified copy. Such
24.
May please your lordship, madam. In this case, the petitioner challenges the inaction of the opposite parties regarding cancellation of a work order for construction of a boundary wall of VSS Nagar UGME school, my lord. Well, petitioners are alumni association and they have given a representation to Bhai Annexure 3 to the OP number 2 and 3, my lord.
It is a
Which is
a
pending, my lord.
representation or is it a FIR?
My lord.
It is a representation of the first information report.
This copy was also submitted to IIC VSS Nagar.
No, you are agreed by the cancellation of the work order.
Work order, my lord.
Then what is this, a
No,
PIL or?
not a challenge. Only to stop the work, my lord. Well, after
Go,
within
this is not a
the
PIL, sorry.
What he is trying to say is this. That this
He
contract-
wants cancellation or he is challenging the cancellation?
He wants cancellation.
once cancellation, my lord.
So indirectly tender you want cancel.
Cancellation.
This is not a public interest litigation, I believe. It is not a public interest litigation.
We are the association, alumni association of UGME school, my lord, VSS Nagar, my lord.
Sorry, we will not entertain this kind of public interest litigation. This is
My
a
lord,
completely
this
specific case.
association is this association is established for the development of the school, my lord. And I have the amount was sanctioned for development of the school, my lord, and 50 lakhs, my lord. The contractor has not doing properly, and some irregularity was found in the contractor's work, my lord. For that, I have given the representation to the BDA and IIC VS.
How they can exercise their authority? It is regarding the construction.
My lord.
Then he wants cancellation.
I want cancellation.
May take this, that this contractor was appointed by engaged the BMC, the Bhubaneswar Municipal Corporation, for construction of a boundary wall around the school. They, I believe, according to their pleadings, are the alumni association of the school. What they are saying that the contractor is not carrying out the work properly.
He has taken away the material they had stacked there for which they have given FIR. So that is a different matter.
That's a different matter. And the boundary wall has to be demolished and new boundary wall constructed. Therefore, the old iron, this thing had to be taken away.
Can't take away.
It's a BMC contract. That's what they're saying, that the BMC.
With the help of BMC, he has taken the gate and grill of iron.
That FIR, that is fine. That is separate. So that is, you have other remedy, inaction of police.
The contractor is that period is already over. That concession period is already over. But after that, he is trying to for concession and storing the materials. It is difficult to the students, my lord. Now school is opening, my lord.
Who is there? BMC has a
BMC is the necessary authority. There is already a representation at Annex 3 at page 26.
Why BMC is not taking any action in the allegation cells?
My lord, may direct the BMC authority to dispose of these
No,
immediately.
you get instructions, then something might happen. Dispose of representation.
Because I am for the state, notice may go to the BMC.
Who is the standing council is there?
They have a panel, my lord, so better to go notice is better.
Notice is a
They have a
matter of
big
prosecution.
panel.
All right.
No, that's.
But we do not find any actually material for the public interest
My lord.
litigation. We are asking simple thing. We ask you go to the BMC, file a complaint before the BMC. They can
I have
take the
filed
action.
It's there.
So the BMC, I have filed the representation now.
Go
I
to the
can accept it.
BMC and they do not take.
But some persons of the BMC are helping the contractor, my lord. By the help of some persons, they taken away the materials and he is not doing the work properly and that soil.
No, because you just hear us. The contractor has been appointed by the Bhubaneswar Municipal Corporation, right? And the contractor is supposed to work under the terms and conditions of the work orders, including the agreement that he has entered into. If there is any breach, whether it is the court to take action or the Bhubaneswar Municipal Corporation will take action.
Bhubaneswar municipality should take action, but he has not taken. For that, I come to this on board. Here, I have filed the representation is pending. They are not hearing, my lord. For that, I am coming to this.
Anybody appears in the standing? No. But
They have a panel. They have a panel, my lords, let notice go.
What is your representation to the BMC?
My lord, Bhai Answer 3, page 26.
This is an FIR written to some zonal officer. Ownership principal concern.
Give the page number, give the page number.
Page number 26, I think the representation.
Stolen, again stolen. You have mixed up two things. That is the problem.
First of all, if the contractor has taken away,
Some
no,
metals.
do you know whether it is a part of the agreement that you will remove all the materials that is in the whole structure is there? Have you
The whole
enquired?
should not be removed by the.
What, don't on the basis of any imaginary notion, you cannot proceed in court at least. Because in some things that the salvage is to be taken by the contractor for whatever.
In fact, my lords, may look at page 29 and 30, the photographs of the gate that have been dismantled. Those were dangerous to be lying around there. So if he is building a new boundary wall, that needed to be removed.
Heard, Mr. You are Mr.
S. Behra.
S. Behra and counsel appearing for the petitioner. From the representation dated 17/6/2023, it transpires that some purported irregularities of the contractor who has been engaged by the Bhubaneswar Municipal Corporation
For construction of
for demolition and construction of the boundary wall around the VSS Nagar UGP school. There is a pad, huh? Stop. It has been also alleged by Mr. Behral and counsel for the petitioner that some construction materials have been dumped in such a manner that the safety of the school children who are entering along the no, here's also safety of the school children has become vulnerable. Also asserted by the petitioner that despite the period of completion of work is over, the Bhubaneswar Municipal Corporation has not been taking any action against the contractor. Stop. Mr. General and Counsel has added that the apparent nexus between some official of the Bhubaneswar Municipal Corporation and the contractor is there. And that is the reason, perhaps according to the agreement, no action is being taken by the Bhubaneswar Municipal Corporation. So we are not making any comment on those allegations at this stage, but we would like to issue notice on the opposite parties number 2 and 3, 2, 3, 4, and 5 for filing a short affidavit by the next date. Will the matter be listed on 28/7/2023? So at the time of in the affidavit, they must also clarify whether the representation filed by the petitioner has been considered and due action therefrom has been taken or not. Stop. Mr. D. Naik and Counsel has appeared for the opposite party number
1, my lords.
These all make the opposite parties. Opposite party number 1. So we would also request Mr. D. Naik and Counsel to look to ask the Urban Development Department. No, there is a ask the Urban Development Department to inquire into the allegations of the petitioner through a responsible officer and file a short report by the next date. Who is it? No,
28th.
However, we are not inclined to issue any notice on the opposite party number 8 at this stage.
28th, ma'am.
28. States for service of notice on the opposite parties number 2 to 7 shall be taken by the petitioner within 5 days and within in the course of the day you have to take step. In the course of the day by the step goes to the 80. All right. Let us see
my lord.
what is there.
My lord, unnecessary one may be stayed, my lord.
Nothing would be stayed by this court. We do not know anything. You have not given the agreement copy.
And if he's doing work, why should we stay? You want,
It is already stayed by the
Period was
contractor.
already over, my lord.
No, the contractor has stayed the agreement already, so there will be no form. You say the contractor is not work or period is over. This is over. 115 may calculate.